I thank Congresswoman Debbie Wasserman Schultz for her great work on this issue. And I urge my colleagues to join me in support of this important legislation to protect America's children. And I'll reserve the balance of my time.
Gentleman reserves. Chair recognizes the gentleman from Virginia.
Speaker, I yield myself such time as I may consume.
Without objection, the gentleman is recognized.
Mr. Speaker, I rise in opposition to H.R. 6063. While I can appreciate the apparent attempt in the bill to better protect children who are victims of sexual abuse, not only fails to achieve that objective, but it also presents serious constitutional concerns and other problematic provisions. First, the bill creates a rebuttable presumption in 18 U.S.C. Section 1514 that if an individual posts a photograph or personal identifying information about a person subject to a protective order, it, quote, serves no legitimate purpose, which is an essential element of the offense of harassment and intimidation. This rebuttable presumption would shift the burden of proof in these cases from the accuser to the accused by requiring the accused to prove that posting of the photograph or information about the person served a legitimate purpose. And therefore, under current law and the fundamental principles of the Constitution, the burden is on the accuser to prove beyond a reasonable doubt this element of the offense, not the obligation of the accused to prove his innocence. So this provision violates the constitutional rights of defendants who may be innocent of the underlying charge and who are entitled to be presumed innocent. The coincidental inclusion of a protected person of a family photo posted over Facebook or an email may unintentionally and may merely coincidental, that may be unintentional or coincidental, should not be presumed to be a crime. What's wrong with the normal process by which the accuser has to show that the posting was for harassment or intimidation? To make an innocent person prove his innocence is not only unnecessary and unfair, but unconstitutional. In Francis v. Franklin, a 1985 Supreme Court case, the government argued that the constitutional issue regarding the rebuttable presumption there was overcome by the defendant's ability to rebut the presumption. The Supreme Court, however, found that argument unpersuasive. The Court said that a mandatory presumption instructs the jury that it must infer the presumed fact if the state presumes certain predicate facts. Such a presumption can be conclusive or rebuttable. The key is whether it is mandatory, and that is whether the jury must make a presumption, may be possible to rebuttal if the state proves certain facts. In light of the fact that Section 3D2 of H.R. 6063 explicitly mandates the court shall presume that there is no legitimate purpose, this provision is exactly the kind of mandatory rebuttable presumption that the court repudiated in the Francis decision. And another problem with the bill is it adds a new criminal offense of violating a protective order. Minor activities that are not intended to cause harm or distress, such as a phone call or an email, can result in a federal criminal charge, not as a violation of federal law protecting a witness from harassment or intimidation. There are already laws against that, but as a technical violation of a civil order. Judges already have plenty of laws and authority to protect victims and witnesses. There's already a comprehensive statutory scheme in place to assist judges and law enforcement in protecting witnesses in federal criminal proceedings. In addition to federal criminal provisions with heavy penalties, the authority of judges to enter protective orders for the protection of all witnesses, including children, the judges have immense contempt and other powers to accomplish this goal. Thus, the additional criminal offense is unnecessary and unproductive. We should stop adding unnecessary criminal laws to the criminal code. In previous Congresses, we've had hearings regarding the general problem of over-criminalization of conduct and the over-federalization of criminal law. Members of both parties then expressed concern over this. We already have over 4,000 federal criminal offenses in the code, along with an estimated 300,000 federal regulations that impose criminal penalties, often without clearly setting out what will be subject to criminal liability. This bill is yet another example of adding more unnecessary crimes and penalties to the federal code. Moreover, such a provision moves the protection responsibility from the judge in a case to a prosecutor who decides when there is a violation and when to bring charges for the violations. Given the fact that many proceedings involve child witnesses, also involve family members of the child witness in emotionally charged situations, the addition of more criminal provisions to this mix is not helpful. This provision allows the imposition of a federal felony up to 5 years in prison for a violation. It is unnecessary, overbroad, and harsh, especially given a restraining order can be violated by simply making an innocent phone call. The further problem with H.R. 6063 is it would give U.S. Marshals authority to issue administrative subpoenas to investigate unregistered sex offenders. Now, I'm not convinced that extending this extraordinary ex parte judicial authority is appropriate. Research has clearly shown that registered sex offenders who may not be compliant with the law are actually no more apt to commit a criminal offense than those who are compliant. So there is no compelling reason to create a special authority for U.S. Marshals in the case of registered or unregistered sex offenders. There is no urgent or imminent threat context in rounding up alleged non-compliant sex offenders which, as we just said, are no more likely to commit a crime than those who are compliant with all of the technicalities of the law. The existing statutory scheme for administrative subpoenas for law enforcement focuses on extreme situations, such as the Presidential Threat Protective Administrative Subpoena. We approved that power a few years ago to assist in the protection of the President when the Director of the Secret Service has determined that an imminent threat is posed against the life of the President of the United States, and he has to certify the same to the Secretary of the Treasury, and the Attorney General has the same kind of power in child exploitation cases. Both of these are cabinet-level officials. I offered an amendment to remove the provisions extending this type of judicial authority to U.S. Marshals. Upon failure of that amendment, I then offered an amendment to continue limiting the authority to the issuance of administrative subpoenas to cabinet officials to ensure that this extraordinary judicial power is used discreetly and only in circumstances where it is absolutely warranted. Those amendments were defeated, and therefore this bill gives more power to the Marshal Service in cases where there is no proven need for the power, more power than the Secret Service has when faced with an imminent threat to the President of the United States. Despite serious constitutional issues and other problems, this bill was introduced on June 29th, marked up in the committee 12 days later on June 10th, which was the very next day that Congress was in session. Clearly, these provisions need more consideration. For these reasons, I urge that we defeat H.R. 6063, and I reserve the balance of my time.
Gentleman reserves.
No further speakers on this side and reserve the balance of my time.
Gentleman yields back the balance of his time and recognize the gentleman from Virginia.
Mr. Speaker, I yield such time as she may consume to the gentlelady from Florida, a co-sponsor of the bill.
Thank you.
Recognize the gentlelady from Florida.
Thank you, Mr. Speaker. I rise today in support of the Child Protection Act of 2012, which I'm honored to co-sponsor with my good friend, Chairman Lamar Smith. Chairman Smith and I are proof positive of what bipartisan working relationships can accomplish, especially because we both agree that protecting the safety and well-being of our nation's children is our highest priority. That's why I'm so pleased that this bill, which was reported favorably out of committee on voice vote, is before us today. This is an opportunity to make a real difference in the lives of children nationwide, thousands of whom are plagued by abuse, terror, and assaults that we cannot even imagine. In 2008, I was honored to sponsor the Protect Our Children Act of 2008, which provides the safety net and the resources the law enforcement agents who fight sexual predators so desperately need. This common-sense bill builds on the progress that we started in Protect to ensure that law enforcement can combat one of the fastest-growing crimes in the United States, child pornography. We must ensure that investigators have every available resource to track down predators and protect our children. This bill ensures that paperwork does not stand in the way of protecting our kids. Mr. Speaker, I have learned far too much about the world of child pornography since I first took on this cause 4 years ago. There are many aspects of it that are disturbing beyond words to describe, like the fact that in a survey of convicted offenders, more than 83% of them had images of children younger than 12 years old, and almost 20% of them had images of babies and toddlers who were less than 3 years old. And let's remember that these aren't just images of naked children. These are crime scene photographs and videos of children being beaten, raped, and abused for the sexual pleasure of the person looking at the photo or the video that are beyond our worst nightmares. Let's also remember that these are children who are often being victimized by someone in their circle of trust, someone who was supposed to protect them, and someone who instead chose to do them harm. These children only have the law to protect them because their protectors failed them and caused them harm. While it's not often that we have an opportunity to pass a bill here that quite literally means the difference between life or death, this is one of those times. That's why, as a member of Congress, I know I and Chairman Smith and the members of Congress here today, fighting to protect the children of this country, will stand strong and continue to press forward on their behalf. I'm proud and honored to be the lead Democratic sponsor of this bill, and I'm thankful to my friend Chairman Smith for his continued leadership and support on this crucial cause. As he mentioned, he listed some of the chairman listed some of the organizations that are supporting this bill. I will add some others. This bill is supported by the Rape, Abuse, and Incest National Network, the National Council of Jewish Women, Men Can Stop Rape, and the Florida Council Against Sexual Violence, among the other worthy and proud organizations that Chairman Smith listed. We are grateful to all of these organizations for their endorsement of this bill and for their continued support for all victims of sexual assault and abuse. I urge all of my colleagues to join us in supporting this critical legislation. Thank you. I yield back the balance of my time.
The gentlelady yields back. This gentleman from Virginia seek recognition. The gentleman from Texas.
Mr. Speaker, I yield back the balance of my time.
Gentleman yields back.
Mr. Speaker, I yield back the balance of my time as well.
Gentleman yields back. Question is, will the House suspend the rules and pass H.R. 6063? Those in favor say aye. Those opposed, no. In the opinion of the Chair, two-thirds being in the affirmative, the rules are suspended. The bill is passed and without objection. The gentleman from Virginia. The motion to reconsider is laid on.
Mr. Speaker, I object on the grounds that a quorum is not present. Make a point of order that a quorum is not present.
Pursuant to Clause 8 of Rule 20 and the Chair's prior announcement, further proceedings on this motion will be postponed. And for what purpose does the gentleman from Texas seek recognition?
Mr. Speaker, I move that the House suspend the rules and pass H.R. 4362, the Stop Identity Theft Act of 2012.
The clerk will report the title of the bill.
Union Calendar Number 460, H.R. 4362, a bill to provide effective criminal prosecutions for certain identity theft and for other purposes.
Pursuant to the rule, the gentleman from Texas, Mr. Smith, and the gentleman from Virginia, Mr. Scott, each will control 20 minutes. The Chair recognizes the gentleman from Texas.
Mr. Speaker, I ask unanimous consent that all members may have 5 legislative days within which to revise and extend their remarks and include extraneous materials on H.R. 4362 currently under consideration.
Without objection, the Chair recognizes the gentleman.
Mr. Speaker, I yield myself such time as I may consume.
Without objection.
Mr. Speaker, I am pleased to be an original co-sponsor of H.R. 4362, the Stopping Tax Offenders and Prosecuting Identity Theft Act of 2012, which my good friend and colleague, the distinguished gentlewoman from Florida, Debbie Wasserman Schultz. This is a bipartisan bill that strengthens criminal penalties for tax return identity thieves. Tax fraud is a very real problem, and Congress should do all it can to protect citizens from this costly crime. Tax fraud through identity theft is a rapidly growing criminal enterprise in the United States. Criminals use stolen identities to steal income tax refunds from unsuspecting victims and from the federal government. With nothing more than stolen identity information, Social Security numbers and their corresponding names and birth dates, criminals have electronically filed thousands of false tax returns and have received hundreds of millions of dollars in wrongful refunds. The thieves deceive the Internal Revenue Service and file a return before the legitimate taxpayer files. The criminals then receive the refund, sometimes by check, but often through a convenient but hard-to-trace prepaid debit card. The criminals then wait for the mail to deliver the cards and checks at abandoned addresses. According to reports in the media, postal workers have been harassed, robbed, and in one case murdered as they have made their rounds with their mail trucks full of debit cards and master keys to mailboxes. Tax thieves victimize innocent taxpayers in a number of ways. These thieves will file fake returns under a false name or claim someone who is no longer living as a dependent on their own forms. Often the fraud is not detected until an individual files a tax return that is rejected by the IRS because someone else has already falsely filed and claimed their return. The IRS has detected 940,000 fake returns for 2010 alone, with which identity thieves would have received $6.5 billion in refunds. And those are just the ones they caught early. It is estimated by the IRS that they missed an additional 1.5 million returns with possible fraudulent refunds worth more than $5.2 billion. The number of these cases has increased by approximately 300% every year since 2008. H.R. 4362 is a bipartisan bill that strengthens criminal penalties for tax return identity thieves. It adds tax return fraud to the list of predicate offenses for aggravated identity theft and expands the definition of an identity theft victim to include businesses and charitable organizations. H.R. 4362 also improves coordination between the Justice Department and state and local law enforcement officials in order to better protect groups that are most vulnerable to tax fraud from becoming future victims. The changes to federal law proposed by H.R. 4362 are important to keep pace with this ever-increasing crime. Tax identity theft costs American families and taxpayers millions of dollars each year. It also results in confusion and needless worry as taxpayers must work to correct the ID problem created by the false filers. It is critical that we take further steps to reduce the number of people who are victimized by this crime. Again, I want to thank Congresswoman Debbie Wasserman Schultz for her great work on this issue. And I urge my colleagues to join me in support of H.R. 4362, and I'll reserve the balance of my time.
Gentleman reserves. The chair recognizes the gentleman from Virginia.
Thank you, Mr. Speaker. I yield myself such time as I may consume.
Without objection, the chair recognizes the gentleman.
Thank you. Mr. Speaker, I rise in opposition to H.R. 4362. It amends federal aggravated identity theft statute to add tax fraud to the list of predicate offenses. The penalty for aggravated identity theft is a mandatory term of imprisonment of 2 years or for a terrorism offense 5 years. This bill would therefore subject more people to mandatory minimum sentences and therefore to all of the problems that have been repeatedly shown to be associated with mandatory minimum sentences. Fraud and identity theft are serious and growing problems, but what we do to address the problems of fraud and identity theft should be measured and effective. While I appreciate the sentiments and efforts behind H.R. 4362, I cannot support an effort that seeks to stop one injustice by applying another. Because of the mandatory minimum sentences included in H.R. 4362, this bill is not an appropriate or effective solution to the problem of identity theft. I'm not saying someone who commits these crimes should not be sentenced to 2 or 5 years or even more, but it is inappropriate and unjust for Congress to sentence an offender based solely on the name of the crime years before any of the facts or circumstances of the case or the role in the particular case and the character of the defendant are known and taken into account. Mandatory minimum sentences have been studied extensively and have been found to distort rational sentencing systems, to discriminate against minorities, to waste the taxpayers' money, and often to violate common sense. Even if everyone involved in a case, from the arresting officer, the prosecutor, the judge, even the victim, after all of the facts and circumstances of the case are presented at trial by the prosecution and defense, if they all conclude that the mandatory minimum sentence would be an unjust sentence for a particular defendant in a particular case, it must still be imposed. Mandatory minimum sentences based merely on the name of the crime remove the sentencing discretion and rationality from the judge and often require him to impose sentences that violate common sense. This is what brings about the results such as girlfriends who end up with much more time than their crack-dealing boyfriends and often have to serve terms 10, 20 years or more. Teenagers having consensual sex with their girlfriends, getting 10 years. Or a recent case of Marissa Alexander in Florida, a mother of 3 and a graduate student, who was sentenced to a mandatory minimum 20 years for discharging a gun to warn off an abusive husband during a dispute. Warning shot. Ironically, if she had intentionally shot and killed him under those circumstances, the maximum penalty for voluntary manslaughter in that state is 15 years. If you want to know how those mandatory minimums pass, just watch this bill. I offered an amendment at the committee markup of the bill which would have provided a maximum sentence of 4 years and 10 years instead of the 2 or 5, respectively. That way, offenders whose conduct warranted it could be sentenced to higher amounts of time if their conduct, if it was appropriate, but for those whose conduct did not, such as bit players who play a minor role in a minor offense, the judge could arrive at a proper sentence. It is the height of legislative arrogance, in my view, for Congress to conclude that it is in better perspective to arrive at an appropriate sentence in advance, knowing nothing about the facts and circumstances of the case, than the judge charged with that responsibility who has heard all of the facts and circumstances of the case. In addition, Mr. Speaker, the Department of Justice has recently expressed concerns with the bill, which indicates that we should have had a legislative hearing on the bill to hear from stakeholders and those who have concerns about the legislation. Even though I support the intent of the sponsors to do more to address identity theft, for the reasons stated, the 2- and 5-year mandatory minimum sentences make this bill indefensible, and I cannot support it. I reserve the balance of my time.
The gentleman reserves the balance of his time. The gentleman from Texas seek
Mr.
recognition.
Speaker, I'll reserve the balance of my time as well.
The gentleman reserves. Recognize the gentleman from Virginia.
Mr. Speaker, I yield such time as she may consume to the gentlelady from Florida, the sponsor of the legislation.
Recognize the gentlelady from Florida.
Thank you, Mr. Speaker. I rise today to urge my colleagues to support H.R. 4362, the Stopping Tax Offenders and Prosecuting Identity Theft Act of 2012, or simply the Stop Identity Theft Act. Many of you have seen the recent headlines calling attention to the escalating nationwide epidemic of tax return identity theft. An unsuspecting taxpayer goes to file their tax return only to be told by the Internal Revenue Service that someone else has already filed and claimed their hard-earned tax refund. This happened to one of my constituents, Joan Rubenstein, who is a 64-year-old teacher. When her accountant filed her 2010 tax return in April of last year, he was told by the IRS that she had already filed. Joan followed advice and filed a police report and reached out to the IRS. But after 10 months, she still had not received her refund. Only after working with my district office were we able to secure her refund, which she desperately needed to assist her daughter with her student loan payments. For her 2011 tax return, Joan was informed by the IRS Taxpayer Advocate's Office that she was okay to proceed with filing her return this year. Yet, shockingly, Joan's accountant filed only to learn that she was once again a victim of tax return identity theft for a second year in a row. No one should have to go through the trauma of having their hard-earned tax refund stolen, and certainly not 2 years in a row. And Joan is not alone. This case, unfortunately, is not an anomaly. My office has been inundated with constituents who have also had their tax refunds stolen. And I know that this is a rampant problem in Chairman Smith's district and his home state of Texas as well. The amount of theft that goes on with this type of case is really astronomical. It's stories like Joan's that prompted me to file this legislation that is before us on the floor today. The crime of tax return identity theft has quickly emerged over the last few years, and Congress must act to quickly address this epidemic. Tax return identity theft wreaks emotional and financial havoc on hardworking taxpayers like Joan and costs the federal government billions of dollars. In 2011 alone, Mr. Speaker, the IRS reported, now listen to this number, 851,602 tax returns and $5.8 billion were associated with fraudulent tax returns involving identity theft. That's a 280% increase since just 2010. These tax return identity thieves hide behind a veil of technology by stealing Social Security numbers and filing false electronic returns where the payoffs are almost instantaneous. Right now, more thieves and criminal organizations are turning to this lucrative, low-risk, high-reward crime because law enforcement lacks the kind of stiff criminal penalties afforded many other forms of identity theft. Essentially, because of the small likelihood of getting caught and the very minimal current penalty, It makes sense for these thieves to roll the dice, because the chances of getting caught and actually doing any time at all is very low. In this instance, technology has simply outstripped the enforcement tools that are currently on the books. Basically, this crime is worth it to the criminals that are committing it, and we need to make sure that it's not worth it anymore, so they don't have incentive to continue, and they move on to the next thing, and then we can go after them for that. We must protect the thousands of taxpayers like Joan who fall victim to this crime, many of whom belong to vulnerable groups like seniors, veterans, and even minors. The Stop Identity Theft Act brings together several measures to strengthen criminal penalties and increase the prosecution rate of tax return identity thieves. H.R. 4362 will add tax return fraud to the list of predicate offenses for aggravated identity theft. The aggravated identity theft statute was created in 2004 to fight identity theft crimes committed to facilitate other types of felonies. However, at the time, the problem of tax return identity theft was very new, and it wasn't included as part of the predicate offenses under aggravated identity theft. Today, it's become an urgent nationwide problem, and we must give law enforcement the additional tools needed to combat this crime. Each of the last 2 administrations have called for adding tax fraud to the predicate offenses under aggravated identity theft. With this change, the Stop Identity Theft Act will toughen sentencing for tax return identity thieves, which will help deter this kind of crime. Importantly, the legislation also expands the definition of an identity theft victim to include businesses and charitable organizations. Often these organizations, Mr. Speaker, have their identities stolen and used in phishing schemes to extract the sensitive information from unsuspecting taxpayers used in tax return thefts. Essentially what happens, and we've all been warned about this, you get an email from what you think is your bank or the charitable organization that you're used to giving donations to, but it's really not, because these thieves have stolen that organization's identity, and they are asking for your personal information, and unsuspecting victims give them that information. By the way, you should never do that, because your bank and a charitable organization won't ask you for personal information. But these thieves then use the harvested information to file thousands of fraudulent tax returns. In fact, on the IRS website, it is noted that this type of phishing scheme is the most common one seen by the IRS. This amendment to the identity theft statutes will ensure that thieves who misappropriate the identities of any business, be it a small business or a nonprofit organization, can be prosecuted. The Stop Identity Theft Act also calls for better coordination between the Department of Justice and state and local law enforcement to make the most efficient use of the law and resources. My own local law enforcement agencies in South Florida have been flooded with crime reports of tax return identity theft, and they need all the help they can get. Finally, the legislation also calls for the Department of Justice to report back on trends, progress on prosecuting tax return identity theft, and recommendations for additional legal tools to combat it. Information and data on trends about tax return identity theft can be valuable tools to detect and prevent future fraud, and it will inform Congress of additional legislative actions that would help in the effort. This legislation is just the strong beginning of the congressional effort to combat tax return identity theft. I know this issue is deeply concerning to many of my colleagues, and I look forward to working with them in their efforts. This legislation is intended to provide targeted tools for law enforcement right away, so that it is better prepared before next tax season rolls around and we have more victims who are really going to have months and months of problems and billions of dollars lost. I want to thank Chairman Smith for your support and your leadership on this issue. It really is a pleasure to work with you, and to the various organizations that have supported and helped craft this legislation. In particular, I'd like to recognize the National Conference of CPA Practitioners and the American Coalition for Taxpayers' Rights for their support and efforts with this bill. We must ensure that federal laws are keeping pace with emerging crimes such as tax return identity theft. It is time to make the prosecution of tax return identity theft a greater priority. The Stop Identity Theft Act is an important step toward this goal, and I urge my colleagues to support this legislation. Once again, thank Chairman Smith for his leadership in working with me on this legislation. I yield back.
Gentleman from Texas. The gentleman from Virginia.
Mr. Speaker, I reserve the balance of my time.
Mr. Speaker, I yield back the balance of my time.
And
The gentleman from Virginia yields back.
And Mr. Speaker, I'll yield back
Gentleman
as well.
Thank you. The question is, will the House suspend the rules and pass H.R. 4362? Those in favor say aye. Those opposed, nay.
On the grounds that a quorum is not present, make a point of order that a quorum is not present.
Opinion of the Chair, two-thirds being in the affirmative, the rules are suspended. The gentleman from Texas makes a point of decorum.
Yeah. Mr. Speaker, I object on the grounds that a quorum is not present. Make a point of order that a quorum is not present.
Pursuant to Clause 8 of Rule 20, further proceedings in this question will be postponed.
Okay.
For what purpose does the gentleman from Texas seek recognition?
Mr. Speaker, I move that the House suspend the rules and pass H.R. 6062, the Edward Byrne Memorial Justice Assistance Grant Program Reauthorization Act of 2012.
The clerk will report the title of the bill.
Union Calendar Number 457, H.R. 6062, a bill to reauthorize the Edward Byrne Memorial Justice Assistance Grants Program through fiscal year 2017.
Pursuant to the rule, the gentleman from Texas, Mr. Smith, and the gentleman from Virginia, Mr. Scott, each will control 20 minutes. The Chair now recognizes the gentleman from Texas.
Mr. Speaker, I ask unanimous consent that all members may have 5 legislative days within which to revise and extend their remarks and include extraneous materials on H.R. 6062 currently under consideration.
Without objection.
And, Mr. Speaker, I'm going to ask unanimous consent to put my entire statement in the record, and I'd like to yield as much time as he may consume to the gentleman from Pennsylvania, Mr. Marino, who is a member of the Judiciary Committee and the sponsor of this legislation.
Without objection, so ordered. The gentleman from Pennsylvania is recognized.
Mr. Speaker, Chairman Smith, I rise today in strong support of legislation I introduced, H.R. 6062, the Edward Byrne Memorial Justice Assistance Grant Program Reauthorization Act of 2012. The Edward Byrne Memorial JAG Program is the primary provider of federal criminal justice funding to state and local jurisdictions and has been referred to as the cornerstone federal crime-fighting program. The JAG program provides state and local government with critically needed resources to support a wide range of law enforcement activities, including prosecution, prevention, education, planning, correction, treatment, evaluation, and technology. As a former district attorney and as a United States attorney, I understand the tremendous value of JAG-funded projects in fighting crime by improving the processes, the procedures, and operations of criminal justice systems. My legislation being considered today reauthorizes the JAG program for 5 years. I repeat, for 5 years through fiscal year 2017. This legislation is supported by the National Criminal Justice Association, the International Association of Chiefs of Police, the Major Cities Chiefs Association, the National Sheriff's Association, the National District Attorneys Association, and many more law enforcement organizations. H.R. 6062 enjoys bipartisan support, including Chairman Smith and Ranking Member Conyers of the House Judiciary Committee, who are co-sponsors. The legislation was considered by the House Judiciary Committee and approved by a voice vote on July 18. I would like to thank the Chairman and the Committee for their help in ensuring that the authorization for this critical program does not lapse. I urge all of my colleagues to join in the support of our state and local law enforcement agencies by voting in favor of H.R. 6062. Thank you, Mr. Speaker. I yield back the balance of my time.
The gentleman from Virginia is recognized.
Mr. Speaker, I yield myself such time as I may consume.
The gentleman is recognized. So ordered.
Mr. Speaker, I rise in support of H.R. 6062, the Edward Byrne Memorial Justice Assistance Grant Program Reauthorization Act of 2012. The federal justice grants reauthorized under this legislation provide critical funding to state and local jurisdictions in their efforts to combat crime, especially during periods of national budgetary constraints affecting the bottom lines of states and local governments. The bill's Byrne JAG grants are particularly important. Across our nation, many jurisdictions, to shore up their budgets, are actually laying off police officers. When many of our citizens are experiencing economic hardship, we must not add to their burden by allowing public safety to suffer. H.R. 6062 reaffirms the federal government's commitment to assisting state and local governments in their effort to prevent and fight crime. But reauthorization of the Byrne-JAG grant program is obviously just a first step. We must also follow through with actually appropriating sufficient funds for the program. In addition, we should encourage allocation of grant funds to the full range of programs that state and local governments are allowed to fund. Under current law, state and local governments may use Byrne-JAG funding for programs or projects that improve law enforcement efforts, prosecution and court programs, prevention and education programs, corrections and community corrections, drug treatment programs, planning, evaluation, and technology projects, and crime victim and witness programs. Each of these are essential to a comprehensive effort to protect us from crime, and therefore all of them should receive significant funding under the Byrne-JAG grant program. An imbalance in justice assistance creates an imbalance in anti-crime efforts. Specifically, an appropriate amount of funding should be allocated to prevent crime, which will help reduce the amount of money needed to fund the after-crime costs of investigation, prosecution, incarceration, and victim assistance. And we must also assist state and local governments to fund public defender programs in recognition of the fact that the public is also protected from injustice when we safeguard the Sixth Amendment rights of our citizens. Finally, it is essential that the full range of other programs that assist state and local public safety initiatives, including the COPS program, are adequately funded. The COPS program has funded the hiring of more than 123,000 state and local police officers and sheriff deputies in communities across our nation, and it has been proven to be extremely effective in reducing crime. I'm proud to be a co-sponsor of H.R. 6062, and I commend the gentleman from Pennsylvania, Mr. Marino, for his work on the bill. Mr. Speaker, I urge adoption of H.R. 6062 so that we can reaffirm our commitment to funding public safety programs, and I reserve the balance of my time.
The gentleman reserves. The gentleman from Texas.
Mr. Speaker, I reserve the balance of my time as well.
Mr. Speaker,
gentleman from Virginia.
I yield such time as he may consume to the gentleman from New Jersey.
The gentleman from New Jersey is recognized.
Thank you, Mr. Speaker, and I want to thank my colleague from Virginia for yielding me the time. I just want to reiterate what Mr. Scott just said. I have to say I have never had more requests and concern about programs from mayors and elected officials in my municipalities than I get for programs like this Byrne-JAG program, like the COPS program, like the SAFER program that deals with fire prevention. I think a lot of it has to do with the fact that many of my towns, and I'm sure this is true across the country, because of the recession, because of budgetary constraints, are laying off police, laying off firemen, don't have the resources, if you will, to deal with a lot of the crime prevention problems. So these programs are crucial to them. And I want to reiterate what Mr. Scott said about the fact that right now it's not only a question of reauthorizing, but also making sure that there's adequate funding for it. If I could just use an example in my own district, and that is last week I was able to announce that several towns in my district, the 6th district, have been awarded grants under the Byrne-JAG program to support a broad range of activities to prevent and control crime. One grant is administered by Neptune and is benefiting both Asbury Park and Long Branch, Long Branch being my hometown. Another grant is administered by New Brunswick and is helping Perth Amboy, Edison, and Woodbridge. The funding is used to purchase law enforcement equipment and supplies. In New Brunswick, it's being used for a police vehicle, which will have mobile video and data equipment. This is really all about community safety, which is of utmost importance. At a time when our local law enforcement has to cope with difficult funding levels, these federal grants make it possible for towns to support critical crime prevention activities that protect New Jersey families and their residents. I can't stress enough how important this is. So I'm just very pleased today that on a bipartisan basis, We are reauthorizing this, I think, for 5 years. And as Mr. Scott said, the next step is to make sure that there's adequate funding because this is a crucial program. That's why I came down here tonight to speak about it. I yield back the balance of my time.
The gentleman yields back. The gentleman from Virginia is recognized.
I thank the gentleman from New Jersey, and I yield back the balance of my time.
The gentleman yields back.
Mr. Speaker, I'll yield back the balance of my time as well.
The question is, will the House suspend the rules and pass H.R. 6062? Those in favor say aye. Those opposed, nay. In the opinion of the Chair, two-thirds being affirmative, the rules are suspended and the bill is passed.
Mr. Speaker,
the gentleman from Virginia.
Mr. Speaker, I object to the vote on the grounds that a quorum is not present and make a point of order that a quorum is not present.
Pursuant to Clause 8 of Rule 20, further proceedings on this question will be postponed. For what purpose does the gentlelady from North Carolina seek recognition?
Mr. Speaker, I send to the desk a privileged report from the Committee on Rules for filing under the rule.
The clerk will report the title of the bill.
Report to accompany House Resolution 747, resolution providing for consideration of the bill H.R. 6169 to provide for expedited consideration of a bill providing for comprehensive tax reform, providing for consideration of the bill H.R. 8 to extend certain tax relief provisions enacted in 2001 and 2003 and for other purposes, providing for proceedings during the period from August 3, 2012 through September 7, 2012, providing for consideration of motions to suspend the rules and waiving a requirement of Clause 6A of Rule 13 with respect to consideration of certain resolutions reported from the Committee on Rules.
Referred to the House calendar and ordered printed. For what purpose does the gentleman from Texas seek recognition?
Mr. Speaker, I move that the House suspend the rules and pass H.R. 1550, the Federal Law Enforcement Recruitment and Retention Act of 2011, as amended.
The Court will report the title of the bill.
H.R. 1550, a bill to establish programs in the Department of Justice and in the Department of Homeland Security to help states that have high rates of homicide and other violent crime and for other purposes.
Pursuant to the rule, the gentleman from Texas, Mr. Smith, and the gentleman from Virginia, Mr. Scott, each will control 20 minutes. The Chair now recognizes the gentleman from Texas.
Mr. Speaker, I ask unanimous consent that all members may have 5 legislative days within which to revise and extend their remarks and include extraneous materials on H.R. 1550 as amended, currently under consideration.
Without objection.
Mr. Speaker, I yield myself such time as I may consume.
The gentleman is recognized.
Mr. Speaker, H.R. 1550, the Federal Law Enforcement Recruitment and Retention Act of 2012, was introduced by my friend and colleague on the Judiciary Committee, Mr. Pierluisi of Puerto Rico. It helps focus the Justice Department's law enforcement efforts on the areas of the country that need them the most. Crime in the United States began to rise sharply in the 1960s and continued up to its peak in the early 1990s. In response, Congress and the states reformed their criminal laws to include tougher penalties and truth in sentencing laws, and they dedicated additional resources to target the rising crime rate. To a great extent, our national focus on crime has been successful. The national violent crime rate in 2010 was almost half of what it was in 1991. And crime in the United States has continued to fall in spite of difficult economic times. The violent crime rate fell 5% from 2008 to 2009 and another 5% from 2009 to 2010. Despite this good news, we are far from a solution to the problem of violent crime in all areas of the country. There are still areas where violent crime remains a very serious issue and is even on the rise. For example, in my district, the number of murders in the city of Austin nearly doubled in 1 year, going from 22 homicides in 2009 to 38 homicides in 2010. Puerto Rico, home to the sponsor of this bill, has experienced an increase in drug-related violent crime. With more than 1,100 deaths in 2011, the homicide rate in Puerto Rico last year was more than 5 times the national average. The majority of this violence is attributed to the area's growing drug trafficking trade, which has implications, of course, for mainland U.S. The problem of high crime areas may increase if there are not sufficient federal law enforcement officers in these communities. To address this situation, the Justice Department started to dispatch surges of federal law enforcement officers to prevent and investigate crime in high crime cities like Philadelphia, Pennsylvania, and Oakland, California. H.R. 1550 continues this momentum. It directs the Department of Justice to consider, in coordination with state and local governments, the need to recruit, assign, and retain federal law enforcement personnel in areas of the country with high rates of homicides and other violent crimes, which of course should include Puerto Rico. H.R. 1550 has bipartisan support and has been endorsed by the law enforcement community. The bill was reported out of the Judiciary Committee on a voice vote, and once again I want to thank Mr. Pierluisi for sponsoring this legislation. H.R. 1550 improves the safety of the many Americans who live in fear of violent crime in their neighborhoods. So I urge my colleagues to support the bill, and I'll reserve the balance of my time.
The gentleman from Texas reserves. The gentleman from Virginia is recognized.
Thank you, Mr. Speaker. I yield myself such time as I may consume.
The gentleman is recognized.
Mr. Speaker, I rise in support of H.R. 1550, the Federal Law Enforcement Recruitment and Retention Act. This bill would require the Department of Justice to prioritize the placement and retention of personnel in those states and local jurisdictions that have high incidences of homicide and other violent crimes. The recruitment and retention of law enforcement officers has become increasingly difficult in recent years. These challenges are faced not only by state and local police agencies, but also by federal law enforcement agencies. Difficulty in recruiting and retaining law enforcement officers is particularly acute in jurisdictions that experience high rates of violent crime. In fact, the high incidence of crime in a jurisdiction can deter a federal law enforcement officer from seeking assignment in that jurisdiction and can frequently lead to high turnover. The failure to retain a law enforcement officer has been estimated to result in approximately $100,000 in additional costs for the Department of Justice. H.R. 1550's amendment aims to address this problem by directing the Attorney General to give priority in placing and retaining agents in jurisdictions with particularly high crime rates. This bill also requires the Department of Justice to annually provide Congress with a detailed report on how it is implementing this directive. H.R. 1550 is a modest but necessary measure to focus our crime-fighting efforts on the areas most in need. I, too, want to commend our colleague, the gentleman from Puerto Rico, Mr. Pierluisi, for his work in developing this bill. I urge my colleagues to support H.R. 1550 and reserve the balance of my time.
The gentleman reserves.
And, Mr. Speaker, I'll reserve the balance of my time as well.
The gentleman reserves.
Mr. Speaker.
The gentleman from Virginia.
Thank you, Mr. Speaker. Mr. Speaker, I yield such time as you may consume to the gentleman from Puerto Rico, the sponsor of the legislation, Mr. Pierluisi.
The gentleman from Puerto Rico is recognized.
Thank you, Ranking Member Scott. Mr. Speaker, I want to begin by expressing my gratitude to the Chairman of the Judiciary Committee, Lamar Smith, for supporting H.R. 1550 and for working with House leadership to schedule the bill for floor consideration. I also want to thank the Ranking Member of the Judiciary Committee, Congressman Conyers, the Chairman of the Crime Subcommittee, Congressman Sensenbrenner, and the Ranking Member of the Crime Subcommittee, Congressman Scott, for their support. H.R. 1550 was unanimously approved by the Judiciary Committee and has been endorsed by the Federal Law Enforcement Officers Association, which represents over 25,000 federal law enforcement officers employed by 65 agencies. The short title of this bill, as modified, is the Federal Law Enforcement Personnel and Resources Allocation Improvement Act of 2012. The bill would direct the Department of Justice, when allocating law enforcement personnel and resources among U.S. jurisdictions, to give priority to those areas of the country that have high rates of homicide and other violent crime, including forcible rape, robbery, and aggravated assault. The bill would require the Attorney General to designate an existing official within the Department of Justice who will be responsible for developing practices and procedures to implement this directive and for monitoring compliance with the directive by the Department's component agencies, including the Federal Bureau of Investigation, the Drug Enforcement Administration, the Bureau of Alcohol, Tobacco, Firearms and Explosives, and the United States Marshal Service. Finally, the bill would require the Attorney General to submit an annual report to the appropriate congressional committees. The report would specify which jurisdictions have a high incidence of homicide or other violent crime and would identify the steps that the Department of Justice is taking to prioritize the allocation of law enforcement personnel and resources to those high crime areas. In addition, the report would describe the methodology that the Department is using to determine the total number of authorized federal law enforcement positions nationwide, to allocate those authorized positions among different jurisdictions, and to assign personnel to fill those authorized positions. The basis for H.R. 1550 is as follows. In recent years, the number of murders and other violent crimes nationwide has decreased substantially. Between 2007 and 2011, for example, the total number of murders in the United States decreased by over 20%, and the total number of violent crimes decreased by nearly 18%. Most U.S. jurisdictions, whether urban, suburban, or rural, have experienced a meaningful reduction in murders and other violent crimes. From the macro perspective, the progress we have witnessed has been real and in many cases remarkable. Much of the credit is due to law enforcement officers on the federal and local levels. Enhanced and effective policing can make and has made a tremendous difference in our communities. Unfortunately, certain jurisdictions, sometimes referred to as hotspots, have been exceptions to this steady downward trend in violent crime. My own district, Puerto Rico, is a case in point. Today, the number of annual murders in Puerto Rico is nearly 90% higher than it was in 1990. Between 2007 and 2011 alone, homicides rose by 55%, with most of the violence linked to the drug trade. Yet, the federal law enforcement footprint in the U.S. territory has not evolved in light of these changed circumstances. Instead, it has remained stagnant. Puerto Rico may be the most dramatic example of a U.S. jurisdiction where violent crime has increased rather than decreased, but is by no means alone. For example, Flint, Michigan experienced a 73% increase in homicides between 2007 and 2011, while a major metropolitan area in the Central Valley of California witnessed a 100% increase in murders. Moreover, there are numerous other areas where there has been some progress in reducing crime, but where violence remains far too high. Examples of such areas include Detroit, St. Louis, Memphis, Oakland, Little Rock, Birmingham, Atlanta, Baltimore, Philadelphia, Chicago, Miami, and New Orleans. H.R. 1550 would promote and institutionalize steps that the Department of Justice, to its credit, has already begun to take. Recently, the Department developed a new initiative known as the Violent Crime Reduction Partnership to help target federal resources to areas in need of additional law enforcement support. Pursuant to this initiative, for example, more than 50 officials from the FBI, DEA, ATF, the U.S. Attorney's Office, and DOJ's Criminal Division have begun a 4-month surge of federal law enforcement resources in order to prevent and combat violent crime in the Philadelphia metropolitan area. This is a positive step that should be encouraged and replicated in other high-crime jurisdictions, which is the precise result that H.R. 1550 seeks to bring about. To be clear, it is well understood that the methods that DOJ may successfully employ to reduce violent crime in, say, Philadelphia or Baltimore may need to be adjusted for use in San Juan or St. Louis, with a specific approach dependent upon the nature of the crime problem that each jurisdiction confronts and other relevant factors. For that reason, my bill does not in any way try to micromanage the department or to promote a one-size-fits-all approach to fighting crime. H.R. 1550 simply seeks to ensure, in this time of fiscal constraint on both the federal and local levels, that DOJ has in place a carefully crafted and consistently applied policy of allocating limited law enforcement personnel and resources to those areas where they are needed the most. Again, I thank Chairman Smith, Ranking Member Scott, and I hope my colleagues on both sides of the aisle will support this bill. I yield back the balance of my time.
The gentleman from Puerto Rico yields back. The gentleman from Texas. The gentleman from Virginia.
Mr. Speaker, I yield such time as she may consume to the gentlelady from the Virgin Islands, Dr. Christensen.
I thank the ranking member
for... The Virgin Islands is recognized.
Thank you. Thank you, Mr. Speaker, and I thank the ranking member for yielding. And Mr. Speaker, I too rise in very strong support of H.R. 1550, the Federal Law Enforcement Personnel and Resources Allocation Improvement Act of 2012, which would require the Attorney General in the allocation of federal law enforcement personnel and resources to give priority to placing and retaining such personnel and resources in states and local jurisdictions that have high incidence of homicide or other violent crime. And I commend my friend, the Congressman from Puerto Rico, Mr. Pierluisi, for its introduction, for his hard work, and for his leadership in getting it to the floor today. If this bill were to become law, my district, along with Congressman Pierluisi's, will be one of the local jurisdictions that would qualify for having that high incidence of homicide and violent crime. This is not a fact that we're proud of, but it is a reality. And it's the byproduct of the USVI and Puerto Rico being a transshipment point for illegal drugs traveling from Central and South America to mainland United States. There are many other communities in our country that are facing the same or similar incidents of violence, and the blame in most cases can be traced to drug trafficking. In the case of the Virgin Islands and Puerto Rico, it stems from the fact that we have become the route of choice for drug shipments to the east coast of the United States. According to Department of Justice statistics, in 2011, 165,000 metric tons of illegal drugs were seized in the Caribbean, Bahamas, and Gulf of Mexico, up 36% over 4 years. And up to 80% of cocaine trafficked through the Virgin Islands and Puerto Rico is directed to U.S. East Coast cities. Congressman Pierluisi and I were recently at a Coast Guard station in Puerto Rico, and we had the opportunity to meet with the commander of a ship that had recently captured 1.4 kilos of cocaine off of St. Croix in the U.S. Virgin Islands. That was the port's largest capture in its history. These routes are also a threat to America's national security. In addition to guns, assault weapons, and drugs, the Caribbean is susceptible to smuggling, nuclear, and all kinds of materials that could easily be used as staging areas for violence against our country. And most tragic of all are the young people, many of whom I knew and took care of as a family physician, who have been killed or who are now in jail. Unfortunately, we too have one of the highest murder rates per 100,000 in our country. Our community was shocked a few months ago when 2 of our young policemen in a high crime area, but on what seemed to be a routine patrol, were shot earlier this year. Both sustained injuries which go beyond the physical. One is paralyzed and will require lifelong care and support. Our community, though, is fighting back. Our law enforcement has been meeting with those from across the Caribbean region. We're working with the federal law enforcement that does exist in the territory. Both of us, Puerto Rico and the U.S. Virgin Islands, jointly have a high-intensity drug trafficking, high-intensity drug trafficking area. We have a well-integrated but still incomplete team led by Adjutant General Vincennes from Puerto Rico and Executive Director Catherine Mills from the Virgin Islands. But we do need more federal help to help restore the safety of our communities and protect the lives of our children. This is not only important to my constituents and me, it's critical to the well-being of the constituents of all of our colleagues, but especially those with high homicide and violent crime rates. And so in this legislation, which I'm pleased to co-sponsor, we are pleading for this critically important help to bring the vital federal resources to save our community and to save all of our communities and to protect our nation. I urge our colleagues to support H.R. 1550, and I yield back the time.
The gentlewoman yields back. The gentleman from Virginia is recognized.
Thank you, Mr. Speaker, and I thank the gentlelady from the Virgin Islands and the gentleman from Puerto Rico. I urge passage of the bill, and I yield back the balance of my time.
The gentleman yields. The gentleman from Texas is recognized.
Mr. Speaker, I yield back the balance of my time as well.
The gentleman yields. The question is, will the House suspend the rules and pass H.R. 1550? Those in favor say aye. Those opposed, no. In the opinion of the chair, 2/3 being in the affirmative.
Mr. Speaker, I object on the grounds that a quorum is not present, make a point of order that a quorum is not present.
Pursuant to Clause 8 of Rule 20 and the Chair's prior announcement, further proceedings on this motion will be postponed.
That's it.
The Chair lays before the House the following personal requests.
Leaves of absence requested for Mr. Bishop of Georgia for today, Mr. Heinrich of New Mexico for today, Ms. Jackson Lee of Texas for today, and Ms. Sutton of Ohio for today.
Without objections, the requests are granted.
There's no minority. Yeah, we'll do 28.
It's good to see you.
Under the Speaker's announced policy of January 5, 2011, the gentleman from Texas, Mr. Carter, is recognized for 28 minutes as the designee of the Majority Leader.
Thank you, Mr. Speaker.